What's up, everybody? It's Jason Cruz with an edition of the Legal Submission. We're taking it to the video this time because we can. Big news out of the UFC antitrust lawsuit. Last weekend, Judge Richard Boulware issued his opinion finally after years of waiting. The class certification for the plaintiffs has been certified in part, meaning that the plaintiffs' bout class of individuals can now proceed in litigation as a class, meaning that upwards of 1,200 former and maybe current UFC fighters can be a part of this lawsuit against Zuffa. I say in part the class was certified because another request for the fighters that were claiming harm based on image rights, identity rights, the judge denied their class certification. These are the individuals that claim to have These are the individuals that claim that their image rights were used by the UFC and were not properly compensated. You may recall that John Fitch was let go by the UFC when he refused to sign his video game agreement to have his likeness appear in one of the UFC iterations of its video game. He was subsequently reinstated, but the issue remained that the UFC, according to the plaintiffs, had a take it or leave it scenario regarding the right to use the likenesses and images of its contracted fighters. So let's look at the bout class. For everyone's sake, according to the plaintiffs in its pleadings, the bout class contains all persons who competed in one or more live professional UFC promoted MMA bouts taking place on broadcast in the United States from December 16, 2010 to January 30th, 2017. The bout class excludes all persons who are not residents or citizens of the United States unless the UFC paid such persons for competing in a bout fought in the United States. What that means is that a lot of the individuals that have been a part of the UFC just for even one fight during this time period could claim a portion of this particular lawsuit. What are the potential damages that the UFC is up against and the plaintiffs are seeking? Well, the experts for the plaintiffs, including Dr. Halsinger, indicated that at upwards of $1.6 billion with a B could be recouped by the plaintiffs as an actual damage sustained by these fighters during this time period. One of the controversial issues that occurred during this contemplation of class certification is how did the plaintiffs come about their damage claims? This all came down to essentially a wage share versus a wage level comparison. The overarching theme was that wage level analysis was the dominant or predominant the wage level analysis was the modern way of indicating whether or not a class of individuals were damaged economically. Dr. Halsinger came up with a wage share analysis where he analyzed the particular revenues earned by Zuffa over a period of time in proportion to the amount obtained by the fighters. Through this amount, he indicated that the numbers showed that fighters were receiving between 18 to 20 20% of the revenues Zuffa earned, and the analysis also dictated that Zuffa obtained this amount through predatory means, anti-competitive anti-competitive scheme, things that are against the Sherman Antitrust Act, which indicates that which indicates that you cannot have the unlawful restraint of trade through means such as a monopoly or a monopsony. Monopoly being control over the buyer's market, monopsony meaning control over the sellers in that market. So what happens next? Well, once the judge orders his opinion, it is almost certain that both parties, plaintiffs and Zuffa, will go ahead and file an appeal. There is a potential that you could file a motion for reconsideration within the same district court, but that goes to Judge Boulware, who is unlikely to overturn his own ruling. The appeal would go to the Ninth Circuit Court of Appeals, and that process takes a long period of time. According to a Sportico article, it usually takes about 2 years for an appeal to occur, from the time it's filed to the time an opinion is issued. And even at that time, the opinion will merely order back to the lower court a decision for which the Judge Boulware would basically abide by the decision and rule upon. So meaning if they overturn class certification and denies class certification, the Ninth Circuit Court of Appeals would issue that order for Judge Boulware to deny class certification. During this time, the entire case probably will be stayed, meaning there's a freeze on all deadlines, any filings that may occur. At this particular point, which is Tuesday, December 15th, there are particular timelines which are beginning to run as far as the going to litigation. Now, if you were to be on the side of the plaintiffs, you would probably appeal the identity class denial, which relates to the rights of those fighters that believe that they were mismanaged or denied their rightful revenues related to the use and appropriation of their image and likeness. Notably, Nate Quarry's claims are going to end if there is not an appeal regarding the identity class, because he would not fit in the battle class based upon the times that he fought. He did not fight between December 16, 2010 and June 30th, 2017, from what I understand. So how long will this happen? Well, there's 14 days from the issuance of the order for a party to file an appeal. So we should probably know before or maybe at the beginning of 2021 whether there will be an appeal. So the clock could take us into, like I said, 2023 to 2024, and even when a Ninth Circuit Court of Appeal issues an order, there is the belief that there might be another appeal, and that would probably go to the Supreme Court, or there are other ways in which they could have the Ninth Circuit could have an en banc hearing where it's heard by the full panel of Ninth Circuit Court judges. The likelihood or unlikelihood of that, we don't know as of yet. We haven't got. We might dive a little more into that as it becomes more apparent for that to happen. But that's again something we'll have to look forward to. In summation, it would seem as though that this was a win for the plaintiffs. If they had a denial of the class certification for both counts, they probably would be out of luck. There might have been an appeal, but again, the fact that the lower court would have denied the class action certification probably would present an uphill battle for the plaintiffs at that time. However, since the ballot class has been accepted as a class, there is a good deal of hope on the plaintiff's side. And for Zuffa, there is a lot of risk because they could be paying out a whole bunch of money and an inevitable appeal. They have the money to go forward with all of this, and I don't foresee them backing down, or at least settling at this particular point. They will likely go forth with an appeal and see what happens at that particular level. Once again, Jason Cruz, the legal submission, will continue to follow this as it is likely to trudge on into 2021. Thanks a lot, folks.